Strap yourself in, there's a lot to cover in this video. From a police commander sacked over drugs, lies and cheats costing the taxpayer tens of thousands of pounds, and of course, that case where the guy was in public and burnt the Quran, now convicted, suggests that we now have a blasphemy law by the back door, and with respect, there's a strong argument that the judge got this wrong, because there is authority, which I'll point you to in the second half of this video, so please do stick around for that. In the meantime, please do subscribe to the channel. I will be your voice of brutally honest commentary on legal matters, news, and of course politics as they arise. So thank you very much for subscribing. Let's take a look at this first story here. Let me give you the timelines first. This police commander had allegations against him, allegations that Julian Bennett had been smoking cannabis between 2019 and 2020 before work, which obviously, I hope goes without saying, is against the rules. These were just allegations. Now, in July 2020, he was asked to provide a urine sample, which, as people on that sort of job would expect to do. So he was asked to provide a urine sample, obviously to test for drugs because of the suspicion that he might have been using drugs. But he refused. And because he refused, 3 days or so later, he was suspended from duty on full pay, which a lot of people might be a bit frustrated about because that would be quite a hefty salary. Then it took 3 years for the initial misconduct hearing to find him guilty of misconduct for refusing the drugs test, and he was dismissed from the Met. However, in July 2024, the Police Appeals Tribunal quashed that decision on procedural grounds, citing that there were issues with the panel's ruling procedures. And now here we are in 2025 with a new misconduct hearing outcome confirming the gross misconduct for refusing the drugs test, and once again Bennett has been sacked for a second time. Now, post-dismissal, he's also been added to the College of Policing's barred list, prohibiting from future police employment. So let's go to some comments on this from the Met Police Assistant Commissioner Matt Twist. Said that he was enormously concerned that almost 5 years since this initial incident happened, we've only now been able to dismiss Commander Bennett. This should have been a simple matter, he said, saying that Bennett had never disputed that he refused a lawful order to take a drugs test. Mr. Bennett has been suspended on full pay for an extraordinary length of time. He said, "I'm sure Londoners will be as outraged as we are at the utter waste of public funds spent paying a senior officer to sit at home, suspended, and not work." So many of you might think that he should owe that money back, but rules would probably have it that that's not going to happen. And the irony doesn't even stop there. It may surprise you to learn that Mr. Bennett now stands disgraced and dismissed and barred from ever doing police work again, wrote the force's drugs strategy for 2017 to 2021 as a commander for territorial policing. And he remained suspended on full pay throughout the entire proceedings for refusing to take a drugs test because he may well have felt that that would go against him, because obviously if he's found to have been using drugs whilst he's on the job, then that might well mean that he gets dismissed for exactly that. But also refusing the drugs test they saw as gross misconduct and therefore grounds for dismissal. It should be said, so I will say it for completeness, in response to the 2023 ruling, Mr. Bennett's solicitors said at the time that the panel found that Commander Bennett did not take any drugs, cannabis or otherwise. The panel found him guilty of refusing to take a drug test, something that he had always admitted. And so this is one scenario that proves my point and my philosophy of system and reality. The reality being the way things actually work, the system being how they should work. So I agree with Assistant Commissioner Twist here. This should have been absolutely clear-cut, slam dunk, takes 20 minutes to come to a decision. If a police officer refuses the drugs test, that should be gross misconduct. They should be out of the door the same day. That's in my personal view. Because if the rules say that you should not be using any illicit substances on the job, and therefore you should submit to a test whenever it's required, regardless of whether you've actually been using any substances or not, if you are to submit to a test, then you are to submit to a test. And if you refuse to do so, that would be grounds for misconduct and grounds for dismissal. That should have taken all of 20 minutes to really come to that decision. It should have been a sit down with an advisor if necessary and say, you are required to do this. If you don't do this, it will lead to that. And if you don't do that and it leads to that, then it's led to your dismissal. That really should have been it. Instead of that, we've had a senior police officer paid almost 5 years at full pay because it took a length of time for the initial hearing and then that was quashed for procedural issues or whatever the reason was. And now it's been done again and they found, well, he did refuse the drugs test and it is gross misconduct and he has been suspended. Now, in just a moment, another area where people are cheating the system out of tens of thousands of pounds worth of money. And do we have blasphemy laws in the UK following this recent conviction? Both of those coming up in just a moment. Don't go away. And then another topic very quickly. Many of you will be going on holiday very shortly, if not imminently. And when you travel about, you will be wanting to connect to Wi-Fi networks because you want to stay connected to the internet wherever you go, whether that's in a cafe, at a services, or even BNBs and things like that. So if you do that, I would strongly urge that you take up a deal with one of my partners on this channel, which is NordVPN, because that will help to keep you safe. Because NordVPN has a whole host of different features, but they are all designed and geared around security. It gives you an anonymous IP address so that you cannot be tracked and traced as to what your activity is online. It has a comprehensive threat protection feature, which will stop web trackers, dangerous websites, and stop you from downloading malware, as well as the added benefit of getting rid of adverts. I'll show you that in just a minute, and lots of other internet threats. But also, if you need to stay connected to your files on your home device, let's say you're taking an iPad with you or whatever, and you want to connect to your home machine, you can have a private encrypted network to your own files called MeshNet, provided by NordVPN. But let me just give you an idea what I mean about removing the ads. Sorry, Daily Mail, but this is the Daily Mail I'm using as this example. The middle section, you'll see I've blurred the photographs because copyright, but notwithstanding that, those photographs would be there. But which bit of this can you actually see the article? Well, let's take a look. We can see this bit here, which is the headline, so I'll highlight that. You can see a little bit of this description of that photograph, so I'll highlight that, and then a little bit of the next story down here, so I can highlight that. But that's about it. That's all you can see, apart from the photographs. The rest is just adverts. Top, bottom, left and right. If I bring on NordVPN here, and I just click Quick Connect, you'll see that it very quickly connects to the server, instantly in fact, and then I come back to the article and refresh it, and just look how much cleaner it is once it refreshes. Obviously, the blurs have stayed intact because I use a tool to blur those out for copyright. And now you can look through and browse the article without the intrusion of all those ads. If that isn't worth it, I don't know what is. And as a partner to my channel here, you can get 4 months extra free using my link, nordvpn.com/bbb, because that's the nickname you gave me. So you get 4 months extra free just by using that link on top of any deal that they're currently doing with all those features and packages. I can't possibly talk about them all in one video. And of course, you get a 30-day money-back guarantee if you change your mind. But it is a fantastic service and you get 4 months extra free. So check out the link, nordvpn.com/bbb. It's in the description. And thanks to Nord for sponsoring this video. But another area with a huge waste of public funds, which I dare say is probably not an isolated incident, is this one here. A benefits cheat, 50 years old, who lied about an MS claim, claimed more than £20,000, caught by her own Facebook posts. This is a lesson not to put things on Facebook when they can come back and bite you years later to prove the timeline of what really happened. But this says a benefits cheat mother who lied about an MS claimed more than £20,000 was caught out on Facebook. She said that she was diagnosed with MS in 2005 and in 2020 claims severity of a progressive disease led her unable to stand at the cooker. She also said that she lacked balance and was unable to get out of the bath unassisted. She began claiming £2,300 a month in personal independence payments because she told the DWP that she was anxious leaving the house, and even a trip to the pharmacy to collect her medication left her in tears. However, her Facebook posts revealed a different story. Again, system and reality. What does the paper show and what does the reality show? And just like in the previous case, the system should be really simple. The reality is it takes 5 years and a huge waste of money. And so the system here is she put in all the paperwork and it was accepted. The reality, on the other hand, is she was part of a running group regularly running 5 and 10K races, but an investigation uncovered that she'd completed 73 races between May 2019 and December 2022. But when all of this came to light, she pleaded guilty to dishonestly making a false statement to obtain a benefit and was jailed for 8 months last July. She's now reappeared at the same court for proceeds of crime. This is where if you've received what they call a benefit, that is a financial benefit from the criminal activity, there are further proceedings called proceeds of crime proceedings where they look to recover the benefit from the criminal activity. And therefore she was told that she had to repay £22,386.02 out of an available amount of £60,000. That's obviously deemed to what was available to take it from. And so the judge has ordered her to repay this amount within 28 days or serve 9 months in prison separately in default of that payment. Now we're going to come on to another really controversial story. Do we now have a blasphemy law by the back door in the UK? Because Hamit Coskun was convicted of a public order offence which stemmed from him standing outside burning the Quran. Now, whether we agree with that or not is absolutely not the point. For the record, I don't agree with the behaviour, but that's not the point. My opinion doesn't really count. It's the law that counts. Now, it appears on the face of it that we do have a conviction that appears to be an offence of blasphemy. Now, it's not officially an offence of blasphemy. It's a public order offence, which was obviously this guy burning the Quran and criticising Islam in really awful terms. Now, I have to make a declaration here because whenever I comment on a case, I always like to say what my position is if I'm commenting on it. If, for example, I don't agree with the behaviour and whatever. Now, I have to say I don't agree with the behaviour here. I have a lot of friends and colleagues of the faith, of many different faiths, and I don't agree with this behaviour. But as a lawyer, I will also tell you if I think that the prosecution and the conviction is not lawful, and if I don't think that that should be criminal behaviour. It's reprehensible behaviour, I will say that, but at the same time, I would fight for somebody's right to the freedom of expression to say what they think. Now, much like you see people in videos up and down in marches, they are burning flags, they are shouting and screaming all sorts of different things. It might be reprehensible, whatever the flag, whatever the religion that they're criticising, and whatever they are saying. But it's their right to do so. It is the right to the freedom of expression. There are a number of very strong authorities on exactly this. Whilst I can understand why the judge arrived at the conclusion, I think there's strong arguments that that conclusion is ultimately wrong in law. Now, I understand that this is being appealed with the help of Free Speech Union. Any appeal will be heard by judges and will not in the slightest bit be swayed by my video here or anything that I say. They will hear legal arguments which might be the same as my arguments. I can understand why members of parliament and ministers would not comment on it. That's another issue, but it does give rise to a little bit of controversy here. Let's go to some comment on exactly this from Parliament here. I'll mute myself so you can hear it. Have a listen to this challenge on this offence, and then I'm going to come back to a bit of the judgment on it and a bit of the law. Take a listen to this.
Thank you, Mr. Speaker. Yesterday, a man was convicted of a public order offence after burning a Quran outside the Turkish embassy. The judge said the fact that the man was attacked is proof that he was guilty of disorderly behaviour. This is grotesque and means, in effect, we have a blasphemy law. Does the Justice Secretary believe that this should hold, or will the government back my bill to put an end to all of this madness next week?
Not have a blasphemy law. We are not going to have a blasphemy law in this country. He will be aware that in that specific case, I believe it's going to be subject to an appeal, so it'd be inappropriate for me or any other minister to comment on the details of that matter. But I'm sure once all other channels are exhausted and we have a final resolution, we will be debating those matters in detail in this House.
Now, I agree with the last part of that. That's fair enough. Ministers can't really comment on it because politicians shouldn't be getting involved in the course of justice and so on. But the first bit where she says we don't have a blasphemy law and we will not ever have a blasphemy law, that is actually now the bit that's really open to debate because many people will see this as a blasphemy conviction. Now, I'm not going to go through in great detail because I do think it's offensive, but that doesn't mean it's illegal. But I do think it's offensive what happened. But ultimately, he was standing there, he burnt the Quran, he made all sorts of comments about it, and then he was attacked by two individuals. Now, let me go to the judgment here, which this is a public judgment. It's available to the public. It's not just something that I've happened to find somewhere. I will read one bit of this out in particular and explain why I think it's important. And then I'll bring to your attention a couple of authorities, which I would presume that lawyers are going to do when they do argue this case. if not these authorities like it, because there are quite a few to choose from. But the judge said here that the conduct was disorderly is no better illustrated than by the fact that it led to serious public disorder involving him being assaulted by two different people. Emphasis, neither of whom appear to have any justification for the nature of their response. Now, to me, with the greatest respect to the judge here, I think that is not only a contradictory statement, but I think that it is self-evident that his conduct was not responsible. Allow me to explain. If I read it again slowly, the judge is saying that his conduct was proven to be disorderly by illustration of the fact that it led to serious public disorder because two other people attacked him. But the clarification there in square brackets, neither of whom appear to have any justification for the nature of their response. So I would respectfully suggest that if neither of those two individuals who attacked him have any justification for attacking him, how can it be the case that his conduct was proved disorderly because they acted without any justification? Surely, if that were correct, it would be they were justified in attacking him because of his conduct. Because it can't be both ways. It can't be that his conduct was so bad that it led to and caused them to react that way, and that they were justified in doing so because he provoked them or whatever, because arguably he didn't. Arguably he was making his protest not specifically aimed at these people. And the original CPS charge seems to suggest that that was the original error, in that he was originally charged with causing an alarm and distress to the institute rather than an individual. Now, it need not be a particular individual that it's aimed at, it just might be that somebody else. But that phrase there to me is contradictory. The judge says neither of these individuals had any justification for the nature of their response. But there's more, because when we engage free speech, we also consider whether it's political or whether it is specifically in regard to a religion or belief and so on. And so then we have the bit in green that I've highlighted. It was suggested on behalf of the defendant that the conduct was not disorderly because none of the language was aimed at a particular person, but religion in general. That it was not stopping anyone going about their business, and he was not obstructing anyone. The combination, timing and location of the conduct, the burning of the book accompanied by abusive comments about Islam do satisfy me, the judge said, that I am sure that his conduct was disorderly. And so the only other thing that I would draw your attention to here is that the judge then went on to say that it is necessary to consider that whether he was exercising the right to freedom of thought, freedom of conscience, freedom of religion, and the right to the freedom of expression and of assembly. The judge did say then, I've concluded that he was in part exercising those rights, but then he must go on to consider whether the public interference with those rights was justified and proportionate. And goes on to say that the interference is clearly necessary in this situation to prevent public disorder. But that is where I bring in two separate authorities, one of which is Scotto and the CPS, and the other one is Redmond Bate and the DPP, Director of Public Prosecutions. Scotto was more about written communications, and Redmond Bate was specifically regard to preaching of religion of sorts. I'll come back to that in a moment. Scotto, first of all, at paragraph 43, a fairly famous paragraph here on the freedom of expression. The judge said here, the prosecution, in this case, argument failed entirely to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed the right to abuse another. The judge, in the original conviction, appears to have considered that the criminal conviction was merited for acts of unkindness, calling others names, and that such acts could only be justified if they contributed to a proper debate. Neither prosecution nor judge considered whether some more demanding interpretation of Section 127 of the Malicious Communications Act addressed the question of what legitimate aim was pursued, etc. And so ultimately, judge here is saying that it is a well-established proposition that free speech encompasses the right to offend and abuse another. Now, bringing in the Redmond Bate case, allow me first of all to give you the brief overview of what this case was. The appellant in this case was one of 3 women Christian fundamentalists who'd agreed with the police to preach from the steps of a cathedral. A police officer on uniform foot patrol received a complaint about the women's activities. He went to investigate. No crowd had gathered, but he warned the women not to stop people. He returned later to find that a crowd of more than 100 people had gathered. And here's the real key point here. I will highlight it here. Some members of that crowd were showing hostility. Fearing a breach of the peace, the police officer asked the women to stop preaching. When they refused to do so, he arrested them all for willfully obstructing him in the execution of his duty under Section 89 of the Police Act, 1996. She was convicted, appealed to the Crown Court. The Crown Court upheld the conviction, having held that lawful conduct should, if persisted, lead to a conviction, etc. And so this was appealed by way of case stated, and this is that judgment here. Now, so in summary, people were showing hostility in the crowd of more than 100 people because they were preaching at the steps of a cathedral. This appeal was allowed and the conviction quashed for the following reasons. And then we come down to this bit here. These are the reasons that the appeal was successful and the conviction quashed. Judge said here, among other things, you can read the full thing yourself, but this bit here, in orange first. Free speech includes not only inoffensive, but the irritating, the contentious, the eccentric, the heretical, the unwelcome, and the provocative, provided it does not tend to provoke violence. Now, that's the bit that I think, with great respect, I think that the judge has overreached here to say that the actions of this guy tended to provoke violence. Provoking violence would be me coming to you and say, if you disagree with me, let's have it outside. That's provoking violence. That is me provoking you, almost encouraging you to use violence. Or if you disagree with it, why don't you sort him out? Or words to that effect. That is exercising free speech, but it is encouraging or provoking violence. What he was doing, from what I've seen so far, was not directly aimed at a single individual and not directly provoking violence. Maybe I'm wrong about that, and maybe that's why I'm not a judge. But again, that is a matter of judgment. But one argument is that this is wrong in law. Moving on. Judge said freedom only to speak inoffensively is not worth having. What Speaker's Corner, where the law applies as fully as anywhere else, demonstrates is that tolerance, which is both extended by law to opinion of every kind and expected by the law in the conduct of those who disagree, even strongly with what they hear. So, once again, the law applies as fully as it did everywhere else, demonstrates that the tolerance should encompass the opinions of every kind and expected by law in the conduct of those who disagree, even strongly with what they hear. So to put that much more simply, anyone that strongly disagreed with what they heard and saw this guy do, the law expects them to be tolerant of it. The law expects people to tolerate even what they strongly and profoundly disagree with. Reacting violently is not lawful, not acceptable, and as the judge accepted in the judgment in this recent case, there was no justification for their response. In his words, to pull that back up once more, the wording he used, neither of whom appear to have any justification for the nature of their response. That precisely aligns with the tolerance here that the judge is saying that everyone must have, even if they strongly disagree with those opinions. Now, again, I'll reiterate for what it's worth. I disagree with the behaviour. I strongly disagree with that. But it wouldn't justify me going to beat this guy up because he's burning a book and I find it offensive. I find it offensive on behalf of people that I care about, for example. But if I go and beat him up for it, there's no justification for me to do that. The law expects my tolerance of his views, however strongly and profoundly I disagree with them. Whether I'm of that faith or not, I cannot just say, well, I'm defending my friends over here, so I beat this guy up for doing that. That's not lawful, and I would not be allowed to do that. And therefore, it should not be accepted that his actions provoked my violence, because by the very definition and conceded by the judge here in this case, there's no justification for that kind of a response. Furthermore, from the condemnation of Socrates to the persecution of modern writers and journalists, our world has seen too many examples of state control and unofficial ideas. A central purpose of the ECHR has been to set close limits to any such assumed power. We in this country continue to owe a debt to the jury which in 1670 refused to convict the Quakers William Penn and William Mead for preaching ideas which offended against state orthodoxy. So you cannot respond with violence. The law expects your tolerance. And so the court conclusion here, to proceed as the Crown Court did, the bit in blue now, from the fact that the three women were preaching about morality, God and the Bible, the topic not only of sermons preached on every Sunday of the year, but at least of one regular daily slot on national radio, to a reasonable apprehension that violence is going to erupt, is with great respect both illiberal and illogical. So the court here, and this is an authority of the then Queen's Bench Division. It's now the King's Bench Division. I was at the King's Bench Division, what day are we? Monday. I'll tell you all about that next week. So this was an authority that the law expects your tolerance. It is not an appropriate response. And to say that merely someone preaching their views provokes violence is illogical and illiberal. And the court didn't agree with it. So that really is the final point here. The judge said, and I repeat for emphasis, to proceed as the Crown Court did, from the fact that these three women were preaching about morality, God and the Bible, to a reasonable apprehension that violence is going to erupt, is, with great respect, illiberal and illogical. So that is certainly an argument that this was wrong. So as I said, my video here is not going to have any effect on the course of justice whatsoever, just so there's no ambiguity. There's going to be no jury in this case now. If it's appealed, it will go to the Crown Court with a single judge and two magistrates. And if it's appealed further by way of case stated, it will end up back in the King's Bench Divisional Court, where presumably they will look to authorities like this one. So that is an overview of one possible legal argument against this. But whilst I emphasise I don't agree with the behaviour, but as I said, my opinion doesn't matter. Whether I agree with it or not is irrelevant. You may disagree with the behaviour and disagree that he's been criminalised for it. Let me know very respectfully and carefully in the comments, please. No sort of hateful comments down there, please. Let me know what you think, because this is a democratic society with free and flowing discussion within the bounds that we're permitted before we get prosecuted for them, of course. But that is precisely the point here. This is supposed to be an open discussion that we can all have. So let me know what you think in the comments below. Please do subscribe to the channel for my brutally honest legal commentary. And as always, I thank you so much for watching.